listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
Hi, everyone. Thanks for joining us for another podcast. What's up, Nathan?
Just at my cabin.
Yeah, I didn't know you had one.
I have all kinds of places that I can go with this filter thing.
You got all sorts of secrets.
Now,
there you go.
Now I'm at my cottage and it's harvest time.
Yeah, and I've been there, so I knew you had that. Although you changed the pillows on the swing.
I know we did. Yeah, we made a few updates. I don't know how we preserved pumpkins into August from last year, but we managed to. Shannon's amazing.
Yeah, she's got skills.
She does. So it's been a while since we podcasted.
No, life has been insane. There's so much we need to podcast about, like 10 different topics. So maybe we'll do like a sprint one week where we just hammer like one a day. Boom, boom, boom.
Sounds fun.
Or maybe we'll just go back to once a week and get back on track.
Okay. Well, so today we are going to be talking to our small business owner listeners because there's been a recent decision by the Supreme Court with capital S and capital C, the U.S. Supreme Court, that drastically changes how we will set up buy-sell agreement succession plans. So when we have partners in a business, one of the concerns is if we lost one of the partners, we don't necessarily want to have the partner's estate or the partner's spouse or the partner's family as our new partners, right? So one of the features of a buy-sell agreement is we agree that if a partner passes, then there's going to be a buyout of that partner to his family, to his estate, to whoever he's directed it to. But then the question becomes, does the company have the liquidity to make that buyout happen? And the answer is generally no, and certainly not all at one time. So one way people do this is to just put a big promissory note in place and say the company, the buy-sell agreement specifies what the valuation is for the business, and the note reflects what the buyout is, but that's going to get paid in monthly payments or quarterly payments or annual payments over years, or I've even seen it go decades. And that's not optimal for the family because they need that. They sometimes, or a lot of times, need that value and they need it quick. So the way that we've worked around this in the past is using life insurance policies where we cross protect each other, right? So if there's two partners in the business, there's two life insurance policies, and the business is the beneficiary of the life insurance proceeds if the partner passes. And what that does is allows the business to now instantly have the liquidity that they need to do an immediate buyout for the most part. And so that's been a really effective strategy. But there's always a but, right? I guess there's been some questions on the IRS side of this as to how those proceeds should be treated, and that's where this case comes in.
Yeah, and we usually think of a business relationship as kind of like your work marriage, right? When you go in as a co-owner of a company with somebody and 2, 3, 4 owners, there's usually an agreement kind of specifying what happens when an owner exits, and that buy-sell agreement is really, really important, and being able to fund that buyout if a partner died is really important because you want to take care of their family.
Super important. And the other thing about it is the surviving partner or partners don't want to have to try to do business with the family member or the estate or the family of the partner. So that's the other thing that it accomplishes, is it removes that entire part of the partnership from the business and makes it so they can proceed without them.
Yeah, because if it goes to deceased partner's spouse, then they might not be the same partner, right? They're probably different than your business partner, their spouses. And then if it goes to their kids, who knows what their kid is like from a business standpoint. So to try to integrate them into your as a new business partner is really challenging. And they probably need the money anyways. They probably don't want to sit and be
Make
involved
business
with the business.
decisions or be involved in the day to day.
Yeah.
Yeah. So, and to take it one step further, most operating agreements don't give someone like a family member of a deceased partner the same rights that they give a partner. So it also is not optimal on the family side because they kind of become like a silent partner in the business. They don't really have the same voting rights. They don't have the same decision-making authority. And so they kind of just have to ride shotgun and deal with, whatever decision is made. And that's going to depend on how the operating agreement is set up. But that's another reason that families would want to have this strategy available, is so they could be out,
Get the money and be done. Yeah.
get the money, be out, not have any further responsibility, not have any further worries or concerns, or be stuck in a business where they have no say.
So I helped a client not too long ago whose spouse died, and their spouse was part of a family business, and they didn't have life insurance set up to fund the business buyout. They did have a buy-sell agreement that says you have to buy them out immediately, and it didn't provide for any like promissory note payments. Long story short, after being in court for several years, eventually they got the payout 3 or 4 years later, right? Just wasn't set up right from the get-go. And this person who passed away was in their 30s, right? No one thought they would pass away. They would be the owner to pass away, but they were the family owner that went. And so it just, if you've built a business that has any value over $1 million, that's my opinion, right? If it's worth more than $1 million business, it's really important you and your business partner have a good buy-sell agreement.
For sure. Yeah. So then what's the big deal then? Why is this a problem now?
So what clever like tax planning did would set it up where the business, the company actually owns the life insurance policy, and the business is the beneficiary of the life insurance policy. So if we use me and Nathan as examples, and Nathan passed away, then
I knew you were gonna knock me off just then. I was like, there's no way he's taking himself out. I'm gone.
Yeah. Sorry, Nathan. I tried to say me, but it just wouldn't come out.
All right, it's okay. You're podcasting from a place where your family could hear you, so
yeah,
we don't want them to hear you talking about your own demise. So you can talk about me dying.
I didn't want to freak him out. So if Nathan passed away, then our law firm would receive the life insurance proceeds. And then my buy-sell agreement would say I now need to buy out his wife for his ownership percentage, and we'd get an appraisal or whatever the agreement says and come up with a value. Well, this worked great because life insurance proceeds are tax-free, right? You get it income tax-free. So when that, let's say in this case, it was about $3 million life insurance policy, this Supreme Court case. So if we got $3 million into our law firm, we can go ahead and give that $3 million and buy the ownership back from Nathan's wife. And so she gets the $3 million, we get the ownership back, and we're all good. Well,
nobody pays taxes on it.
No one pays taxes on that life insurance, right? Well, the IRS said, whoa. We think that the life insurance proceeds that the company received should go into the valuation. So in this Supreme Court case, they thought the company was worth about $3.8 million. But when you add in the $3 million life insurance, now it's worth $7.5 million about, right? And so they went from being worth $3.5 million. Sorry, I did that math wrong. $3.5 million to $6.5 million. So the company's value doubled because they're trying to count the life insurance proceeds as an asset of the company. And we won't bore you with all the previous tax arguments, but there was basically an argument that shouldn't be the case. And there was a appellate court case from the courts that said that strategy was okay, and you can't count the income, you can't count the life insurance as an asset. So
a lower appellate court had previously issued a decision that basically was the basis for the strategies. People would cite that as the legal authority for being able to take this approach. And The problem is that's a lower court. So eventually when things go up to the court of final, I'm going to forget the term.
Final determination.
Yeah, the highest court in the land, right? The Supreme Court decision is going to overrule the lower court.
Yeah, so like it's one of those things where
Court
now
of last resort.
court of last
Court of last resort. Sorry.
last chance.
Yep.
So the funny thing about that is like when the lower court made their decision, like their rationale for it, like when you read it, you're like, yeah, that is a little inconsistent with some of the normal accounting principles that you would use and follow. And
Mhm.
so basically what happened was this extra $3 million caused a problem with their estate tax. And so you're like, okay, who cares if they value the company at 6.5 million? That, that usually doesn't matter. But it does matter if it now causes that to go into your estate, and now you have to pay estate taxes on it. And so basically what happened is this business owner, because the IRS says, hey, you have to count that 3 million life insurance, his estate value went up, and the estate tax percentage is 40%. So that turned into about $1 million tax for the family.
Yeah, so like almost $1,900,000 in additional estate taxes.
Yeah,
That's
really
a big chunk. So what now? Because this was July of this year. This was this Supreme Court term. So this is brand new. Are buy-sell agreements dead? Can we never use life insurance again for them?
Great question. So I think moving forward, especially because at the end of 2025, the estate tax exemption drops down from 13 million to 7 million. So a lot more people are going to have an estate tax issue than they used to, especially with just how crazy things have gone, right? A lot of real estate has doubled in value. A lot of businesses have went up in value. There's a lot more business owners who are flirting with that taxable estate where 3 years ago they weren't even close, right?
Yeah.
So bottom line is life. If you add in the life insurance, you can take someone who wouldn't have to pay any estate tax, and now all of a sudden they have to pay estate tax. So going forward, everyone who owns a business, and this isn't just like if you listen to this podcast, you're like, oh, my business is smaller, I don't need to think about it. That's like these guys, this business was just two brothers who own a business together. It was a small business. The valuation came in at 3.5 million, right? It wasn't like this big operation. So even small business owners need to address this properly. And so what you're going to have to do going forward is, instead of having the company own the life insurance and the company being the beneficiary of the life insurance, the actual owners are going to have to own the life insurance, and the owners are going to have to receive that life insurance. So in this case, if Nathan passed away, I would have a life insurance policy on Nathan, and Mike Haslam, would receive that life insurance proceeds, not my company, not the law firm. And then I would go buy out his wife, Shannon, from Nathan's ownership. So we refer to that a lot of times as a cross purchase agreement, right? All the owners have an agreement with each other to buy out the other person's
spouse or estate, whoever it belongs to. Yeah, this was a company called Crown Sea Supply, two brothers, Michael and Thomas Connolly. I think he said that it was like plumbing supply or something like that. So this is something that you could drive down any street in any town in America and find this business. And they probably never in their wildest dreams thought that they would run into tax issues, let alone $1 million tax bill. So, so yeah, this is for everybody. And especially with that estate tax dropping, that exemption amount, lifetime exemption amount dropping so much in a very short period of time now, this is going to be something that every small business owner is going to need to do. So what I think I hear you saying is every small business owner, first of all, should have the proper documents in place for their business. They should have an operating agreement. They should have a buy-sell agreement. They should have a valuation method already picked out for how they would value their company. These agreements are also in a way, kind of business prenups if we're going to continue with the business marriage, because not all partnerships last forever. In fact, very few do. So at some point, somebody might want to leave or be done, or maybe there's a falling out between the partners. You want to have that agreement in place to prevent needless litigation over how should the business be valued, how should the buyout work, and so forth. So we want that, and you might already have that. If you do, that's great. But basically what we're saying is every small business owner should sit down with an experienced small business attorney, estate planning attorney, somebody that knows both those areas of law, and have their buy-sell agreement reevaluated, have the strategy, the financial strategy that underlies their buy-sell agreement reevaluated in light of this decision, to avoid getting whacked to the tune of $1 million in an estate tax, or more or less. But these are amounts these are not insignificant amounts of money that are being sent to the IRS because a strategy is struck down in this case, or going forward because people didn't update their strategy as a result of this change in the law. And so that'd be the real shame. Like, these guys probably had no reason to believe this was ever going to blow up in their face, right? But now everybody has reason to believe that this is going to blow up in their face. The warning shot has been fired. And so smart business owners they're going to meet with a trusted advisor, and they're going to have this strategy reevaluated to make sure that we take advantage of every remaining option to legally avoid these unnecessary taxes.
Yeah, and there's a new strategy that, well, not new, but one that's we've referred to as where you actually use a life insurance trust to avoid these estate tax. And there's a way to use it for a business. A lot of people just use life insurance trusts for their personal estate tax planning, but there's a way to use it for a business. So I think with this new Supreme Court ruling, that strategy of using a life insurance trust for your business is going to become very popular. You can also use another LLC to do this strategy, and that might become more popular as well. So advisors, you need your trusted advisor to kind of review with you your business buy-sell agreement. If you do use life insurance to fund that, what makes sense. If you don't use life insurance to fund it, you should probably have a conversation with them about if that makes sense and if that's a viable option for you, because it does really make things a lot better if you can do that. Mm-hmm. And really just rethink this issue, because we now know we can't just go ahead and have the company buy the policies and call it good.
And not include that money in the valuation.
Well, I think that covers it, Nathan. So thanks for another great episode.
Yeah, we just want to remind you that we are attorneys. We do this kind of work. But the purpose of our podcast is not to give you legal advice, not to set a specific strategy for your business. It's for educational and entertainment purposes only. But do use that information to meet with somebody that is qualified and experienced in these areas, and make sure that you're taking all the necessary precautions to minimize your tax burden in the event of the loss of a partner.
Well said. Well said. Well, thanks everyone for joining us. We'll catch you next time, and have a great day.
We'll try not to make it 6 months before we record another episode.
Yeah, we'll do it shorter. And one other note, Nathan, when you're at your cottage, I was impressed at how long your cat laid in the same spot.
I didn't even know I had a cat.
I was also impressed with that. Like
that I didn't notice that the cat was there.
That you got a cat. I didn't know you had a cat.
Let's see if I can find that again. I don't even know what you're talking about. Where is my cat?
Right over your, I guess it'd be your left shoulder to you. Oh, there it is, right?
Oh, yeah.
Yeah.
That's insane. It almost looks like a cougar. It's a big cat.
Yeah, it still hasn't moved the whole podcast.
Sleeping hard. Okay, thanks for joining us, everybody. We'll see you next time.
See ya.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.